This is quite frankly a nonsensical post. The definition of feminism is the advocacy of women's rights on the basis of the equality of the sexes. She says, demanding that women be defined by our biology isn't a win for feminism. It quite literally, definitively is. I really can't believe that there are so many people, newspapers, organizations still fighting against the judgment of the Supreme Court in favor of women's biological definition and associated rights in the Equality Act. And many people are asking the very simple question, does this now mean that organizations, companies, such as gyms and hotels and restaurants, etc., should they now provide definitively separate single-sex spaces, such as toilets and bathrooms and changing rooms, for women and girls against men and boys? And the simple answer is yes. And the longer answer is they always could lawfully exclude any trans person, whether certificated or not, more about that in a minute, from those spaces under the Equality Act. It was always lawful for them to do that if it is a proportionate means of achieving a legitimate aim. Now it is even more crystal clear than it ever was before, but allow me to share with you some of my bookmarked tweets or posts, if you like, from people, MPs, newspapers, and all sorts of people that are still complaining essentially about this judgment, somehow arguing that it is attacking trans rights, which it isn't, somehow saying that it's taking away trans rights, which it isn't. In fact, this judgment doesn't change those at all. The judgment doesn't change substantially any law at all. It just clarifies what the law always was. And so this is not now a change in the law that now going forward, this is how everybody must operate. This is how it should have operated all along and how Parliament intended it all along. And Parliament must have intended it to be biological definitions as against any certificated definition. So allow me to share with you a few tweets, a few more references to the judgment. I told you it would spill over to more than one video. But first of all, please do subscribe. I put a lot of effort in reading into these videos, and I'd be really grateful if you do that. About half of you don't, but that's how my channel grows. I keep asking because that's what works. So I'm really grateful to you for doing that. But let's move on to share with you some of these, and then I'll jump over to the judgment. Leave me your thoughts and comments below. But I will caveat the whole of the video by saying, as I think I did in my other video, that this is not a blanket permission to harass anybody, to mistreat anybody, to be malicious, to attack anybody. All of those things were already unlawful. They remain unlawful. And this is not a blanket pass to do any of those things. Of course, if you attack and mistreat anybody on that basis, it was unlawful. It's still unlawful if it crosses a threshold. And just to clarify the caveat, I'm a lawyer after all, it is not going to be unlawful just to say your views or to say what you believe if it's a fundamentally philosophically protected belief or a statement of fact that someone is a man or a woman per the definitions that the Supreme Court has now set. And let's get to some of the tweets. Enough caveats, but here we go. Let's take a look at these are my bookmarks here. The first bookmark here from Richard Bergen MP. Now, I've criticized one or two tweets before. I may agree with one or two things he says, but I disagree with many things that he says. He says here, I've been in touch with constituents and friends who are trans, and it hurts to see such hostility on some of the media and online as they try to get on with their lives. Now, that much may well be true. But then he says, like everyone else, trans people in our communities deserve to be treated with respect and live free from hatred, which is also true. But I do question really whether or not these complaints originate from a misunderstanding of what this law does. Because this law from the Supreme Court does not take away any rights. It does not change any rights. Effectively, it just clarified what the law always was. Joanna Cherry KC commented on a post here. I'll read her quote post first. She says, this sort of childish, silly student politics is blighting our country and has set back the course of independence by years. Feminists and lesbians who went to court to defend our rights are not right-wing. This line is tired and offensive and wholly without evidence. And she's talking, of course, about the post beneath it, which again, very tiresomely labels anyone that criticizes something like this as right-wing. The National, which is the newspaper that supports an independent Scotland. So the National newspaper, Scotland, says, Are we really meant to believe that the right-wing voices which have celebrated the ruling truly have women's rights at heart? Well, if you want my honest and brutally honest opinion, yes, they do, whether they're right-wing or not. Now, I don't accept that they're right-wing, for the record, but some of them might be right-wing, and there's nothing really wrong with that. You might be left-wing, you might be right-wing, you might be a total centralist, you might have views on both sides, which may make you a centralist, but it doesn't matter, because I do believe that people that were supporting the case that has now won in the Supreme Court, I do believe that they were supporting women's rights, biological women's rights, and those of feminists and lesbians, etc. I do believe that they were fighting for those rights, and it doesn't matter whether they're right-wing or not. I don't accept that they're all right-wing for argument's sake, but it doesn't really matter. But nonetheless, that's what the newspaper says. And this is why I'm so surprised by these responses. And it doesn't end there. Amnesty International, it's sort of almost a passive-aggressive response here. They say, a reminder, transgender people's rights are human rights. Well, they are protected rights under the Gender Recognition Act in a very limited sense. There's a great post, which I will link below, which if I scroll to very quickly, you'll see here, by Dr. Michael Foran, who did an interview with the Times Radio here broadcast and explained all of this in much more detail than I'm going to in this video. But this little snippet, but the trans rights that are protected largely limit the protection to interactions with the state, such as documentation, registrations, and so on. And of course, there remains protection of gender reassignment, but it is limited to discrimination solely on the basis that they have a gender reassignment protected characteristic. So, for example, if an employer were to say, I am not employing this person because they have a gender recognition certificate, etc., that obviously would remain discriminatory, unlawfully. But it doesn't change anything else. So back to the tweets. They say, Amnesty International posted, living free from discrimination is a human right. So this is obviously a response to this judgment. They obviously don't support, well, in my view, reading this, they obviously don't support the judgment at first blush. And it's simply a little bit misguided because these rights have not been taken away. It just clarified what rights they had in the first place. And it hasn't really changed a great deal. But moving on, we have another MP here, Nadia Whittam. Attacking the rights of a marginalised group isn't a win for feminism. Now, I will say that the Supreme Court here said that they counsel against considering this a win by one group against another. And I suggest that broadly that is true, but some people do see it as a win for one category, being women whose rights would necessarily be marginalised if the ruling went the other way and allowed any trans-identifying person or certificated trans person into women's-only spaces. Because, as it repeatedly mentioned throughout the judgment, that would otherwise lead to very absurd and curious scenarios where you would have biological men on maternity wards, etc., or entering female-only spaces such as bathrooms, changing rooms, and women's sports, etc. And so many people will see this as a win for women's rights. The MP goes on, demanding that women be defined by our biology isn't a win for feminism. That's just nonsensical to me. Let's repeat that for clarity. She says, demanding that women be defined by our biology isn't a win for feminism. Isn't that not the very definition of a woman? Quite literally, a biologically female adult human? This is quite frankly a nonsensical post. The definition of feminism is the advocacy of women's rights on the basis of the equality of the sexes. I've even brought up the dictionary definition for you so you can see it in white and black as it happens, because I'm using dark mode, but in white and black and white being the text, obviously. But it is literally the definition. So again, to repeat for emphasis, I know some of you don't like the repetition. Some of you do, live with it. She says, demanding that women be defined by our biology isn't a win for feminism. It quite literally, definitively is, because this now in law from the highest court of this land defines a woman in the Equality Act as a biological woman and biological man for men. But as per my previous video, I think this mostly affects women. But by the by, that's just my interpretation of what's going on in the country. She then goes on to say, the people driving this are not acting in the interests of women. I think they quite literally are. So again, nonsensical statement in my personal opinion. She says, they're taking us all backwards and ushering in the far right. Now again, the tiresome phrase of the far right. Anything they disagree with, they label you far right. And I think this is utterly preposterous, a little bit childish, utterly student politics, and quite frankly, ridiculous. With respect, Nadia Whittam, I think this is utterly ridiculous. I think that should be retracted. It won't be, but I think that's completely bonkers. But never mind, moving on. I was most surprised to hear this clip from LBC, which I'll play to you in a minute, from a barrister, no less, Samantha Kane. So this is what was said in this clip with LBC, and I'll tell you what I think about it afterwards. Take a listen to this.
The ruling of yesterday was entirely misinterpreted because, of course, the judges cannot define what is a man and what's a woman. It's not for lawyers or judges to define that. They just simply gave an interpretation of what parliamentarians meant when they draft the Equality Act. So that's really a very narrow interpretation of that law, which is being badly drafted in any.
Now, I have to respectfully disagree because this is precisely the role of those judges to define or confirm the definition is what they really did in the law. And their interpretation is precisely what everybody should now follow. Because to an extent, the statement is correct in that their job is to interpret what parliamentarians meant when they drafted the law. And it may have created some ambiguity between the Gender Recognition Act and the Equality Act, but the Supreme Court now has quite definitively said this is very clear. It is definitively biological sex. So this is not a narrow interpretation, as suggested here. This is a very broad application of what this definition means throughout the entire Act, which applies to half the population. So this is a very broad meaning, a very broad application of this interpretation, and it is absolutely key to how companies should now act. So I'll just share one or two more bookmarks with you, and it would not be complete without one from J.K. Rowling, who's been very supportive of this case. She says, many women are waiting to hear the Prime Minister's views on the Supreme Court ruling. After all, he's the man who decreed a woman is a female adult. And in addition to that, trans women are women. And that is not just my view, that's actually the law, which is obviously wrong, definitively wrong, because that's what the Supreme Court has now said. But there are some changes that appear to have been made immediately following this ruling. One, as reported by Sky News here, the British Transport Police adopting an interim policy while it digests the Supreme Court's ruling, what the definition of a woman under equality laws is. They say trans women in British Transport Police custody will now be strip searched by male officers, not female, following the court ruling. Query why they didn't phrase it in the way that I think most people will be upset about, in that women should be searched by female officers rather than trans women officers. They do sort of say that a little bit further down, where the spokesperson says, as an interim position, whilst we digest today's judgment, we've advised officers that any same-sex searches in custody are undertaken in accordance with the biological birth sex of the detainee. They couldn't bring themselves to say women will be searched by female officers. And I think they should have done. I think that would have been respectful and the dignity and courtesy and respect that women deserve, to put it quite frankly. But now coming back to the judgment and what companies have to do. And I'm sort of repeating what I said a little bit in the video yesterday, but much more definitively because A, I've had more time to read it, B, I feel a little bit better, and C, lots of people have asked the question and lots of people seem to, not you guys watching, I'm sure it's everybody else, but lots of people seem to misunderstand what companies must now do, or at least in my opinion, and I think Dr. Foreign shares the opinion, companies really ought to do right now, moving forward, now that the law has been clarified. Let's jump back into the judgment. I won't take much of your time, I promise, but it is worth going through. This is a landmark, monumental judgment. I know it's Good Friday, but let's take a look at this. Section 168 of the judgment goes straight to the Equality Act in relation to the protected characteristic of sex, references to a man or a woman. In the Act, man means a male of any age, and woman means a female of any age. And just for someone that did raise in the comments about girls and so on, this applies to all females. And so it's just a simplicity for the language. Woman includes female children, i.e. girls. So it's just a simple way of protecting the entire sex category. And the court says here, although the word biological does not appear in the definition, the ordinary meaning of those plain and unambiguous words corresponds with the biological characteristics that make an individual a man or a woman. These are things that I've said in previous videos. I've said they're absolutely clear, they're absolutely common sense, plain knowledge and language. And I've said that the law should always make common sense, it should always prevail. And I'm so glad that it does, because it gives me faith in the system, in that law accords with common sense, fact, reality, and biology. This is not, again, I stress, to be derogative of anybody or to upset anybody that is trans. I've had conversations with trans, both here, some of you guys watching are trans, and some people I know in real life are trans. Obviously, those rights are protected. And for the vast majority of people that I've interacted with who are trans, either on here or in real life, share the views with me that this should be the way that it is. But these are common sense language things here. The court said these are assumed to be self-explanatory and to require no further explanation. Men and women are on the face of the definition only differentiated by grouping by the biology they share with their group. And it goes on to say a certificated sex interpretation would cut across all of that definition and essentially create complications all over the place. Moving on, 162 to 164, briefly recapping here. Again, there's no reason to suppose that Parliament intended by the Equality Act to introduce a change of substance to the Sex Discrimination Act by introducing any modification with regard to sex under Section 9(1) of the Gender Recognition Act. So that's where there was a little bit of ambiguity, and that's why companies have been terrified, in my view, quite frankly, about what they do. And to put it bluntly, I think companies have been terrified of being sued by a trans person or a trans-identified person for not allowing them to use the bathroom of their choice. And so they've just said, well, use whichever one you please. And therefore, the companies, I think, have decided that they are less likely to be sued by a woman finding a man in their toilets or a man finding a woman in their toilets than they are by the person that feels aggrieved and discriminated against. That's just my view, and that's how I think it's got to where we are now. Moving on, paragraph 177, I've bookmarked here. The court says, as we shall demonstrate a strong indicator that the words sex, man and woman in the Equality Act have their biological meaning and not certificated sex, is provided by section 13, 17, 18, which relate to sex, pregnancy, and maternity discrimination and related provisions. The protection afforded by these provisions is predicated on the fact of pregnancy or the fact of having given birth to a child and the taking of leave in the consequence. Since, as a matter of biology, only women can become pregnant, the protection is necessarily restricted to biological women. The repeated references in those sections to a woman who's become pregnant, who's breastfeeding, only makes sense if it has a biological meaning. These plain, unambiguous words, you'll note how the court uses these phrases again and again and again through the judgment, in the hopes that it makes clear to companies this is unambiguous. These plain, unambiguous words can only be interpreted coherently as references to biological sex, biological females and biological males. Put it another way, if the acquisition of a certificate pursuant to Section 9(1) of the GRA applies to these words, so that biological women living as trans men are male, they would nonetheless be excluded from protection when pregnant, notwithstanding a continued capacity to become pregnant. It would create a nonsense, which I said in my previous video. And finally, the court then does draw a distinction between sex discrimination and gender reassignment discrimination. Paragraph 198. The court said two other core provisions support our conclusion thus far. First, the protected characteristic of gender reassignment is defined distinctly from sex in Section 7 of the Equality Act, and there is no conflation of these separate characteristics. So they are completely separate. First, it says that the gender reassignment is a specific protected characteristic, and then sets out what it is. And then once paragraph 199, accordingly, the Equality Act recognizes sex and gender reassignment as distinct and separate bases for discrimination and equality, giving separate protection for each. So now let's move on to two things. One that says where the protection for gender reassignment does apply and where it doesn't. And it doesn't insofar as separate single-sex spaces are concerned. And I'll highlight bits of the judgment, there are many more, but bits of the judgment that I say support this contention, and the contention that companies should now ensure that those single-sex spaces are indeed separate female and male spaces. They can, and I would recommend that they would provide a third space, but if they didn't, that would be a separate legal argument as to whether there is discrimination against a trans-identified person with a GRC, which I'll explain in a moment, but that's an entirely separate issue. It remains my view that companies should now ensure that it is separate female and male spaces for these reasons. So looking at these sections here, reading from paragraph 201, the court says section 9.1 of the GRA 2004 only applies where a full gender recognition certificate has been obtained. So not self-identification, not just living as or anything else, but a full GRC has been obtained. And interestingly, the court said here, moreover, we've observed, as the data shows, an overwhelming majority of people in England and Wales and Scotland with the protected characteristic of gender reassignment do not have a GRC. And since they've explained above in this judgment, neither possession of a GRC nor the protected characteristic of gender reassignment require any physiological change or even a change in outward appearance. There is no outward means of distinguishing between a person with the protected characteristic of gender reassignment who has a GRC and a person with the characteristic who does not. In other words, you can't tell. It could be, for all intents and purposes, appear on the face of it like a man, but identify as a woman. And the court is saying here that there is no way to tell. So the court then comments on the duty of a company to provide for each of the sexes and indeed to cooperate with the GRA to avoid discrimination against gender reassignment. And the court says here, the duty bearer, i.e. the company with the duty of avoiding such discrimination, says here, the duty bearer, and it's this bit here, the duty bearer cannot ask whether it's been obtained, the GRC. There is, accordingly, no way for duty bearers to distinguish confidently between the two groups when regulating their conduct in accordance with the obligations imposed by the Equality Act. Moreover, it says, in either case, the individual's biological sex may continue to be readily perceivable and may form the basis of unlawful discrimination. So again, the court is quite clearly saying somebody may look at a person and say, this is a man, even if the person possesses a GRC. So the person may have a certificated sex of a woman, but any duty bearer trying to avoid a discrimination claim may look at the person and say, that's clearly a man, which, to put it in the most polite way possible, that is clearly what a lot of people think. It goes on to say a person who has the protected characteristic of gender reassignment as soon as they propose to undergo the process, so it may be at that stage where no change in the outward appearance. The consequence of an interpretation of sex in the Equality Act as extending certificated sex pursuant to sections 9.1 and 2 of the GRA would also create an odd inequality of status between those who share the protected characteristic of gender reassignment but do not hold a GRC. So even between those two, there's an odd disparity, let alone those who have the protected biological sex characteristic. The court goes on. We can see no good reason why the legislature should have intended that people with the protected characteristic of gender reassignment should be regarded and treated differently under the Equality Act depending on whether they possess a confidential certificate, even though in most cases, there would not be any material distinction in their personal characteristics, either as regards gender identity or appearance, or as to how they are perceived or treated by others or society at large. It's a very, very polite way of saying somebody may treat the person and see the person as a man, even if they identify as a woman, even if they hold a GRC as a certificated woman. And then we come to the bit that really applies to companies, organizations, charities, NHS trusts, and other government bodies, organizations across the country. This is the bit that they really ought to take note of. And my view is that they should absolutely take this to heart and provide single-sex spaces based on biology. The bit in blue. The difficulty this interpretation would create for service providers, employers, and other organizations in applying equality law to these groups is obvious. Research referred to by Sex Matters shows that since it is in practice impossible for organizations to distinguish between people with the protected characteristic of gender reassignment who do and do not have a GRC, many organizations feel pressured into accepting de facto self-identification for the purposes of identifying whom to treat as a woman or girl when seeking to apply the group-based rights and protections of the Equality Act in relation to the protected characteristic of sex. The result, in some cases, is that certain women-only groups, organizations, charities have come under pressure, including from fundraisers and commissioners, to include trans women, and policy decisions have been taken to simply accept members or users of the opposite biological sex, either assuming that they hold a confidential certificate or on the basis of self-identification. And there it is. The Supreme Court said in crystal clear language, these companies have felt pressured to just allow people into the women's changing rooms, which is the mostly widely reported. It's men's as well, but it's mostly widely reported for women's changing rooms and bathrooms and women's sports, etc. Companies have felt pressured, organizations have felt pressured to just allow self-identification into those spaces. So what must now happen? In my view, and I'll link you to Dr. Foran's interview below, you can hear his views there as well. But in my view, companies should now categorically, distinctively, and proactively ensure that single-sex spaces remain biologically separate, else they may face a claim for direct or indirect discrimination against those groups. Why, you might ask? Well, here's why. Take the scenario where there are only 2 bathrooms, no sort of unisex, gender-neutral, whatever you want to call it, bathroom, no third bathroom, it's men's and women's. And then let's say that that company, that organization, that restaurant, that gym, that whatever, they allow a trans woman, that is to say a biological man, into the female toilets, which the Supreme Court has now said biology is what counts. Then that company is not protecting women in that space. So then they might face a multitude of different possible claims. One, that they are not providing the adequate building facilities, which depending on when it was built, it may have to provide single-sex spaces under the building regulations, or even if it predated that, they may also face a claim for direct or indirect discrimination on the basis of the protected characteristic of sex, which in the Equality Act definitively, legally means biological sex. That's what it means. That's what they should do. So that's what they should now apply in prisons, in restaurants, in hotels, changing rooms, sports, everywhere. That is my opinion. That's what should happen. And for clarity, again, it does not detract from trans rights. They still exist as they did before, because all the Supreme Court did is clarify what the law always was. It hasn't taken away any of those rights. It does not give a blanket excuse or permission to harass anybody any more than you could before, any more than you could if somebody was from a religious or an ethnic minority. You couldn't do that before, you can't do that now. And you can't do that with gender reassignment before, and you can't do that now. All of those offences remain in place. They include malicious communications, they include harassment, etc. I've had my criticisms of how the police deal with malicious communications, and I think they are over the top with those. That's just my opinion. Many of those should not even be investigated, much less prosecuted, but I have my views on those. But as I say, that's the caveat. It's not a blanket excuse to do any of those things. I'm sure most of you watching don't. It's only a minority of you that don't. And indeed, I believe it's only a minority, and statistics show it's only a minority of people that actually have this issue of identifying into women's spaces. And so the Supreme Court has made this clear. So this was the follow-up video that I knew I would do because I knew the questions would follow. The final question I suppose I will answer before I let you go is, many people have asked, why did the court not say that this is what companies must now do? Because that is not the court's role. The court's role was not to say, you companies must now do this, because that would ultimately amount to an order by the court to do something which the court was not going to do. What the court has done is clarify the law and said, this is what the law means. And so now it has made it absolutely clear that if companies were worried or pressured about providing single-sex spaces and whether they might face a claim, any claim like that would now fail. So to put that another way, if a trans woman wanted to enter a women's only space and the restaurant, the hotel, the gym, the whatever said, no, you can't come in here because it's a women only space. We've defined this as a biological woman's only space. You cannot come in. If they were to face a claim for discrimination, that claim would fail because the Supreme Court has made this absolutely clear. The Equality Act all along made it lawful to exclude them from those spaces anyway. It's just that the Supreme Court has now made this crystal clear in that it refers to biological sex. So there it is. It is as crystal clear as it could possibly be, although many people are trying to conflate it with all sorts of things because they don't like the judgment, etc. But like I say, it's as clear as it could be, but it's not an excuse to abuse anybody. Please do like the video, share the video, comment on the video, do something else with the video, watch it again, bookmark it, all those sort of things. YouTube loves that. It helps my channel grow. I really appreciate it when I'm recovering from being really ill. I don't want to describe how ill, but really ill. So thank you for watching. Thank you for liking, sharing, commenting, subscribing, etc. And I'll see you next time.